All right, so now we have the next panel, which is on tort law and compensation. And it's Ulrika Antesson, professor at the Department of Law at Lund University, who will be chairing this panel. So please go ahead.
Thank you, Hildur. So we have our first speaker is Sharon Cowan, professor of feminist and queer legal studies at the University of Edinburgh. So you have 15 minutes. Please go ahead. Yep.
So thank you. Can everyone hear me?
Yes.
Okay, fab. So I want to first of all say thank you to Hildur for inviting me.
I'm really sorry to do this, but I just wanted to remind everybody, the panelists, to talk into the mic because I had some complaints about people not really hearing.
Okay.
So sorry. Yeah.
Okay, no problem. Can you hear me in the back? Perfect. Thank you, Hildur, for inviting me, and to Eileen for all the amazing organisational skills that she has and encouragement. And also, I just want to acknowledge that the privilege of being able to come here and have this conference be in English, because I don't speak Icelandic or any other Nordic languages, which the taxi driver was telling us yesterday was that some of them are similar and some of them are understandable for people from other countries, but I don't speak any of them, and I just wanted to say thank you for that. That's really a privilege to be able to do that. So I also should say that this is my first time in Iceland, which is very exciting, and I'm really looking forward to learning from other people and their research, and also having a little bit of time to explore the beauty of Reykjavik. And that this is my first time thinking about this particular subject. So my background is in law, and I'm normally talking about sexual offences in the criminal law. I've never really thought about tort and compensation before. This is my first time thinking about this stuff. So right at the very beginning of it. So really happy to learn from what's going on in other places. I know that Hildur's worked on this, and probably there are other people too. So excited to talk about that. The context, I think, as we all know, is that there's some, to put it mildly, dissatisfaction with the criminal justice system. And as one of the speakers in the earlier panel alluded to, there's a lot of work going on across lots of different jurisdictions about what to do about that. Is it possible to avoid criminal justice entirely, to go through the civil law, or is there some other form of extra legal way of dealing with sexual offences through transformative or restorative justice approaches that are not rooted in criminal justice? And how would we go about doing that? So that's kind of the context for thinking about civil law as a potential avenue for addressing sexual violence. I should also just say that I will try to keep within my 15 minutes, which might mean a speedy Glaswegian accent. Vanessa is also from Glasgow and managed to speak quite slowly. If I get too fast for anyone, just like wave and I will slow down. So yes, taking sexual harm seriously, I think, has meant for a lot of people doing it within the criminal context. And there's some questioning now of that, particularly since there is lots of evidence that the context of sexual offences in the criminal justice system is that they're on the rise, and that the conviction rates are not, and there's a lot of dissatisfaction with figures. So just to talk you through this a little bit, there's a project ongoing in Scotland at the moment that I'm conducting with Vanessa and another colleague on sexual history evidence in Scotland, in criminal trials for sexual violence. And as a part of that project, people have consistently been telling us that the High Court that deals with either really serious sexual offences at first instance or appeal cases in sexual violence, their caseload over all the work that they do is around 80% sexual offences. So it's a huge amount of the work that the court does in Scotland. And although the conviction rate for all offences is around 90%, and that's of cases proceeded against, so ones that actually are going through the court system, the conviction rate for rape and attempted rape is about 50%, so almost half the chance of other cases of being a guilty verdict. And just to introduce this idea of the not proven verdict, and when I talk to students about this, they kind of go, what? There are 3 verdicts possible in Scotland in the criminal trial: guilty, not guilty, and not proven. I can try and explain to you what the not proven verdict is, but the short answer is nobody really knows. That's actually true. And the judges in criminal trials who are giving directions to juries on how to deal with cases do not explain the not proven verdict. They say nothing. They just say there are 3 verdicts. Guilty is a conviction, not guilty and not proven are both acquittal verdicts, but they don't explain what is the difference between them. And again, it's partly because nobody really knows what the difference is between them, except there's a sense that a not proven verdict is the jury saying, we kind of know you did it, but we don't have enough evidence to prove it. So that's kind of the backdrop in Scotland. And you can see from the figures that the majority of rape acquittals are through the not proven verdict. And the not proven verdict is used a lot more frequently in rape and attempted rape cases than it is in any other sort of case in Scotland. So that is something I'll talk about a little bit later. So that's the kind of statistical context. I'm not going to talk very much about transformative justice and other alternative routes outside of the legal system because I know other people are going to be talking about that later. I'm going to talk a little bit about what's happened with the civil route in Scotland, given dissatisfaction with the criminal justice system, and in particular 3 cases that have come up in the civil justice context. Now, the reason I'm picking these 3 cases is not because I'm randomly selecting them for my own purposes, it's because there only have been 3 that have taken the civil route after either a not proven verdict in the criminal trial or the criminal proceeding collapsing at some point in the criminal justice system. So a couple of things that you need to know about the Scots criminal procedure and system to understand what I'm going to say. The first one is about the not proven verdict. I've already talked a little bit about that. The only other thing to say is, and here's where I'm flipping the switch, is that Vanessa has done a lot of work on this. So if you have any detailed questions about not proven, that's your person over there to talk to. But there has been recently several attempts to kind of put into question whether we need the 3rd verdict. Various people over time have tried to have it overturned completely unsuccessfully, but there has been a recent consultation that took place, it finished in 2021, so last year, with the public on the not proven verdict and on the second issue, which is a unique feature of criminal law, which I'll talk about in a second, which is corroboration. So there's a recent public consultation on that. And in short, there's public support for switching to a 2-verdict system. I'll not go into that in too much detail because I could go down a complete rabbit hole about that. But needless to say, the shorthand version of where the resistance comes from is from the legal profession, right? So we can talk about that separately if you want to. The second unique feature of criminal law in Scotland that you need to understand for what I'm about to say is the requirement for corroboration. This is not something that is, in my experience, still in place in many jurisdictions. England got rid of it a long time ago, but you need 2 independently verifiable sources of proof for each constituent element of a crime. So not for every aspect of a narration of a story, but the specific key aspects of an offence need to be corroborated by 2 pieces of evidence. The same consultation that they did for not proven also asked about corroboration. The findings there were a lot less stark in terms of support for or against corroboration. But again, in short, there is a fairly split kind of attitudes towards it, with a slight majority for keeping corroboration. The UK, gosh, I should get kicked out of Scotland for saying the UK here. The Scottish government conducted a review of corroboration in 2016, and they actually really seriously toyed with the idea of getting rid of corroboration, but the move failed for various different reasons, mostly political and mostly legal resistance from the legal profession. So that's all I'm going to say about those 2 things. Those are the 2 things you need to know as backdrop for Scotland. I think I've been speaking for 10 minutes, have I? Or 9 minutes, yeah. 9. Going quickly, civil law in Scotland, probably very similar to civil procedure in lots of other countries. I'm not going to talk you through every point there. Obviously, civil courts have the power to award damages. In relation to rape, there's no tort or delict of rape. English law calls it tort, we call it delict. But it comes under the heading of personal injury. And there's no need for corroboration in a civil case in the same way there is in a criminal case. But obviously, the more evidence you have, the more weight it gives to your claim. I'm not going to get into the last couple of points. It came up in the last panel about can you run them concurrently? The short answer is you can run them concurrently, civil and criminal actions. There's some anxiety around the defender in a civil case revealing arguments that they might be making in a criminal defence later down the line. So again, there's anxiety about how you do it in the same way that Vanessa was talking about earlier. So the three cases that I want to talk about in 5 minutes are DC against DG and DR, AR against Stephen Coxon, and AB against Sean Diamond. And you can see on the slide there, I've described why they went to civil court. The first one was the Crown decided not to prosecute. There was an independent review of that decision some years later, and the review also said there wasn't enough evidence to prosecute. And the last two cases there where there was a criminal trial, but a majority verdict of not proven. Again, I don't want to get into majority verdicts. This is something else that Vanessa's done in another piece of research about how juries work in Scotland. So again, directing you to her at lunch if you want to talk about that. So these three cases, the first one was a case where the defender and the pursuer met on a night out. The sex took place in the house of a friend where they were both staying over, both sleeping in the living room, her on the sofa, him on a chair, and she woke up to him having sex with her. She was extremely intoxicated. The judge in the case said that he found her evidence to be cogent, persuasive and compelling, and she was ultimately awarded significant damages of £100,000. The thing I wanted to say about this case was that almost every witness, other than the defender and his friend, supported the assertion that she was intoxicated to the point where she was unable to make decisions, walk, engage properly with the world. She had a very, very high level of intoxication, but she also had a psychiatrist report which formed part of the evidence considered by the court. And important to note in brackets there that she wasn't diagnosed as suffering from PTSD because she had such severe amnesia from the amount of alcohol that she'd had that she actually managed to avoid some of the more triggering flashbacks and so on, but she still had psychiatric evidence that supported her case. After the case concluded, the pursuer waived her right to anonymity and spoke publicly about her experience and her battle to achieve justice. And she'd written to her MP to try to get reasons from the Crown Office, who prosecute cases in Scotland, as to why they hadn't progressed her case, and she hasn't been able to do that yet. So I'm just noting here that severe intoxication and the two defenders in this case were footballers. There were two people involved in this case. The second case, AR against Stephen Coxon, was a student who was out on a night out, got extremely intoxicated, and went back to her flat with someone and woke up again to him. Not woke up to him having sex with her. Remembered, came to in her bed and realised what was going on, that he was having sex with her. Again, lots of evidence about her level of intoxication, extremely high. Both of these pursuers had intoxication in the band that toxicologists call severe to fatal, so like alcohol poisoning level of intoxication. And in both cases, the judges said that that level of intoxication would have been completely observable and obvious to anyone who was around her at the time. There was some also medical evidence in the case that supported her. This is a very famous case in the media. The pursuer is known as Miss M. She's done a very public campaign against the not proven verdict. And she said she just wanted acknowledgement that the rape had happened, And her main focus had been getting justice and not money, which is just as well because after the case concluded, the defender declared himself bankrupt. The last case that I'm going to mention is AB against Sean Diamond, which is a very recent case. Again, involved a high level of intoxication. Again, it was on a night out and with friends. And this was the one actually where they had the sex with the sofa and the chair. The previous case I described that wasn't, I got the facts mixed up. That's this case. The first case I described was her remembering having sex with one defender, not the other, which was the footballers. This one, where she fell asleep on the sofa, she woke up to the guy having sex with her again. So very similar sets of facts in these cases. And there was also a lot of psychological evidence here of the trauma that she suffered as a result. So in all three cases, high levels of intoxication, lots of psychiatric and psychological evidence about the impact of the acts, medical evidence, toxicology reports, and eyewitness accounts. So I'm going to wrap up in like 1 minute, if I can have an extra minute. It just also, this is apropos of nothing. The first case was 2 footballers, and the second 2 cases were soldiers. So there's another paper in there about masculinity that I can't get into. But the interesting points for me are coming from these cases, and I think this is going to be picked up in the rest of the panel today. So this last minute, I'm just going to set up, I think, hopefully what other people are going to say and take this forward, which is there any difference made in these cases because it's a single judge rather than a judge and a jury? And there's some pilot work being launched in Scotland on using single judges in sexual offences trials. What's the difference between liability and criminal responsibility and the message that sends to the public and to the complainer pursuer? What counts as appropriate damages in a civil case? Is there more scope in civil actions to bring forward things like psychological, psychiatric evidence? Because that's the thing that actually is being used to support the claim for damages and wrongful behaviour. And is the civil court's response to sexual harm a better route for all, many, or some complainers? And that depends, I think, on what we mean by justice. And I think that's something that Claire's going to talk about. And then this question of should we be thinking more broadly about extra legal responses, which I said I'm not going to get into because it's not part of what I'm doing today. But again, there are some advantages and disadvantages, which I think Hilda lays out really clearly in her research. And I'm just asking, given all of that, should we be thinking outside of the box, even of civil law? So that's me raced through. I'm sorry I went so fast, but thank you very much.
Thank you so much, Sharon.
I don't know how to get rid of that, so I'm just going
to really interesting. So now we're moving on to our next speaker, and it's Solveig Laugerud, postdoctoral fellow at the Department of Criminology and Sociology of Law at the University of Oslo. So the floor is yours.
Okay. Okay, hello everyone. Can you hear me? All the way in the back? Okay. I'm a postdoctoral researcher at the Department of Criminology and Sociology of Law at the University of Oslo in Norway. I'm not currently working on compensation, but I have been working a little bit on this before, so I will present the compensation scheme that we currently have in Norway, and also a little bit of the criticism against it. And then from 2023, 1st of January, this will change the compensation scheme. So I will say a little bit about the changes, which is a very drastic change, I think. Okay, so, yeah. A little bit about the background first for the compensation scheme we have in Norway. We have a bit of a complicated scheme, perhaps, in terms of a combination of a state-funded compensation scheme and also compensation from the perpetrators. The current scheme is a very generous scheme. It's one that we've had since 1976, and it's criminal injuries compensation for everyone who has suffered physical or psychological injury as a result of a crime. And you can apply for compensation from the state or claim it from the perpetrator in court. And it was actually the Norwegian Bar Association who initiated this in 1976 because they thought that society is committed to protecting its citizens from crime, and it's unreasonable for victims to bear the consequences of crime, of violence, when the welfare scheme doesn't cover such losses. And bear in mind that Norway is a social democratic welfare state as the other Nordic countries, so the welfare state is very strong. And then in the beginning, it was the county governors that decided on compensation. So it was locally decided. But this was also criticized because it meant that all the local governors, they did this differently. So it was kind of an unequal treatment between the different geographic areas. So some places you would get compensation more easily than other places, and also the amount would differ. So in order to kind of secure a more equal treatment, they opened this compensation authority office in 2003. So now they are dealing with all the cases. Okay, so a little bit about the compensation scheme. It consists of 3 parts. One is for economic losses, and then if something is destroyed and you need to compensate it, you can get compensation for financial losses. And then also for permanent and significant injury, which means if you don't have the ability to work at least 100% in the future, then you can also get compensated for that. But this is not very common. None of these are very common in cases of sexual violence. And then you have this damages for non-economic loss or for pain and suffering. And this is very common in Norway. And then, as I said, you can get this from the state or from the perpetrator. And if you get it from the compensation authorities, from the state, it's a written application that you send to them. And if you go through the courts, it's a civil lawsuit or a criminal trial. So the civil lawsuit, that never happens in Norway because you don't really have to go to civil lawsuits. But we have this system that if you report a case to the police and it goes to trial, then the criminal trial covers both the criminal prosecution and civil claims. So it's supposed to be efficient, do the same thing or do both at the same time. So the presentation of evidence and everything is the same, and then you just have 2 different decisions at the end of the trial. So the only requirement is to report the case to the police. And then if it is dropped by the police, that's when you can apply for compensation from the state. And then you will just send this application. You will get help from your victim's lawyer, and the compensation authority, they will evaluate the case based on the police report. So it's only the police report that is the basis for the judgments. And if it's prosecuted, it becomes part of the criminal trial, as I just said. And the thing about this system is also that the standard of proof in these cases are lower than in the criminal cases. So if the case goes to court, the accused might be convicted in court, and if the accused is convicted, then you more or less automatically get compensation because it's a lower standard of proof. If the accused is acquitted, you can still get compensation because the standard of proof is different. And then in terms of cases of sexual violence, we also have this kind of consensus that sexual violence is harmful, so you don't have to prove injuries. So the only thing you have to do is to prove the incident, and that's why they kind of read the police report, and that's why also the presentation of evidence in criminal trial is the same, because you have to prove the incident. And then we have this for kind of a regular rape. It's a standardized amount, which is decided by the Supreme Court, and they does this regularly to make sure that it kind of rises with time. But and then of course, if you're very young, you get more, and then if it's a lesser crime, you get less, etc. Okay. So there hasn't been done a lot of research on the compensation regime in Norway. Most of the research is basically small evaluations of the compensation, both how it works, but also what it means to the people who applies for compensation. So. And most of the research emphasize how important the compensation is, because especially since you can get it when the case is dropped by the police, it's very important in especially cases like sexual violence, because then people feel that the state still believes them, even though the police dropped the case, or even if the accused is acquitted, they still feel like they get something back in a way. So the money in itself isn't necessarily that important, but that they feel that the kind of the state is saying that, yes, we believe you. And then the criticism is both administrative, that it takes that the case processing time is too long. And it is, although it's basically shorter at the compensation authority than in the courts, of course, because it takes forever to go to court. And then all the victims' lawyers, they have complained quite a lot to the compensation authority, saying that they evaluate the cases too strictly. Because of all of this criticism, they did their own evaluation. And actually, they did say or conclude in this evaluation that in some cases, not overall, but like in some cases, they have been too strict. And then I have also done a little bit on this. My focus was on how they evaluate evidence, and I compared how they did it in court and at the compensation authority. And although it's different, one is a bureaucratic office, one is a court with the principle of orality, where everything has to be presented orally. Of course, there's differences, but still, it's based on the police investigation, the same kind of evidence that is in the case. In this article that I looked into this, I concluded that the courts, they rely primarily on credibility appraisals. They do a lot of credibility assessments, and that's allowed also in criminal cases in Norway. You can make a decision only actually on credibility. And credibility means also different things in the two institutions. So credibility in court usually means that you take into account all the witnesses in a case. So if it happens at a party or anything like that with people present, all these people will testify and they will say something about, for instance, intoxication, if it is a incapacity rate, and then all of that kind of make the case of credibility in court. And then evidence, they use all evidence that can corroborate the claim in Norwegian courts. And it's also because we have this freedom of evidence in Norway, so there are no regulation basically on what you can present as evidence. So we also use trauma evidence for criminal courts. So all of that kind of is used to corroborate the claim. And then at the compensation authorities, which is this bureaucratic office, so they only look at a written report. They rely primarily on forensic evidence. They look for forensic evidence, and they hardly ever mention credibility. And if they do, it's based on expert witnesses. So, for instance, if you go and report the incident immediately to the police, then you become credible. So it's kind of the police that makes you credible. And also, if you go and have a forensic medical examination immediately, that's also making you credible. But other witnesses are not used in the same way as the court do. And then they mainly look for evidence to kind of justify their claim in the forensic report from the police report. So it's a clear difference between how they evaluate the evidence, and then actually you also get different kind of cases that you can actually corroborate, and also you also limit, in my opinion, the kind of case or the kind of cases that you can actually give compensation to. Okay, so very quickly about the legal change. So as of next year, it will change because in 2020, the government proposed changes to the State Compensation Act. It basically means that they discontinue the compensation from the state. And they sent this out on public review, and it was a lot of criticism against this because now you have to do a civil claim in court to get compensation, and it's only from the perpetrator. So the only exceptions is if the perpetrator is unknown or deceased or cannot pay. Okay, I'm just very quickly. So 139 consultative bodies, NGOs, and individuals criticized this. Basically, all of them criticized it. And what is also interesting with the individuals is that it's a lot of non-professionals who also made comments anonymously, and that I think is also very interesting. At the end, they decided to do some changes to the final legislation. So it's not going to be court-based anymore, but the stated wrongdoer will be party to the case and have the right to resist bureaucratic processing of the case. So I'm not a legal scholar, but it sounds to me that the result will be the same, that you still have to go to court. So, okay, I have to stop now. Well, we don't know about the future, how this will be, but it will be very interesting to see how it goes. So, thank you.
Thank you so much.
Thank you so much, Solveig. Very interesting. And now we have one more, our final presenter in this panel. It's Carl Dahlstrand, lecturer at Sociology for Law at Lund University. Please The floor is yours.
Okay, yeah. Yes, I think so. There. So, nice to be here in Iceland. I have never been here before, actually. I'm from Sweden. Just the microphone. Sorry, the microphone. Actually, I'm not that. Usually, I don't speak English. Actually, and I will present a research project that is 100% in Swedish. So I have to translate everything. So you have to excuse me if I don't find the right word. Maybe Hildur or Ulrika can help me. But I'm from Lund University, and I have been doing research within victimology for a long time, actually, but I haven't presented in English that often. I have supervised doctoral students, for example, Hildur, some years ago. This project I'm going to present, going back to my thesis 10 years ago. And I decided to do a replica on the same method. So the data that I am going to present came from two research projects. The original presented as my thesis in 2012, and one replica done more or less 10 years after, presented in a report I have here. Exactly, it's in Swedish actually, but my thesis look like this. Is the book. So the data consists of 4 questionnaire surveys, 2 from the original, from the beginning, and 2 from the replica. And the respondents consist of 2 response groups. One web survey with respondents from the general public, you can say, allmänheten på svenska, and one postal survey mailed to crime victims who received criminal injury compensation from the Swedish Crime Victim Authority. And I think it's very good that Solveig made a presentation of the system, because the Swedish and Norwegian system, I think, is more or less the same, actually. There is some difference. Yeah, you talk about these changes, but I think there is similarities. So I will go in detail about that. So it's 2 different populations in this data. Okay, and the number of the respondents is 2,000, close to 3,000. Yes, some of the background, and also some of the theoretical background. I will say just some words. The purpose is to investigate how different types of violation caused by criminal assaults are perceived and valued, to examine how the criminal injury compensation is assessed by victims who have received compensation, as well as a sample of the general public. This about the general public is about, go back to the law actually. According to the law, compensation for a violation of personal integrity should be determined so it reflects the present social norms within the society. That is what they say in the preparatory works to the compensation law in Sweden. So therefore the compensation has to be seen in relation to the context of criminal law, for example, level of punishment and proportionality, or the general sense of justice in society. The general aim, I can say, is to investigate how the application of the law reflects the sense of justice, and how empirical knowledge can supply to the legal field in question. This is a socio-legal project from the beginning. So that is also a kind of theoretical aspect, how these empirical result or knowledge can have a role when you apply or understand the law, actually. So it have the effect or have the role that is the idea from the legislator. So from a meta theoretical perspective, it also deals with the Wittgensteinian concept as rule following and the rule following paradox, maybe how it's possible to estimate non-pecuniary damages or non-economic damages in money, so it really gives redress or satisfaction to the victims. That is some kind of meta-theoretical. Here is an overview of the data. I will have lots of this kind of figures. Maybe can you see it, or maybe it's a little bit too small. But we can see here that experience of sexual offenses or sexual harassment crimes is not that so common in this material. Annat means other when it comes to sex. So we have here 1,000, there it's total 8 from the beginning. Then the next, allmänheten, general public, 2018 it was 39. And then among the victims it was 25. And that was a sample 300, and then the replica it was 13 among 213. So that makes it difficult to make a good statistical analysis on just that group. So I have to make a little more general presentation here. But I will come back to victims of sexual crimes in the last part, because that is the theme of today's. But I have to say that is a problem, even if it's lots of people. So some overall findings I want to present, and it will be lovely to have your comments on this, because this is very Swedish data, and I don't know how it is in other countries so much. But we can see here that it's very similar survey responses, even if there is different measurements in time and response groups. And the question here is, do you think that the compensation should send a signal about how seriously society views private violation crimes such as violent and sexual crimes? And the original study is to the right. So we say in percent, to a very high degree, 52, 55, 52, and 52. And not at all, it's that many percent, 2, 2, and 3, 3. So it's very close to each other, I think. That's interesting. And if you do a statistical analysis, it's no statistically significant difference among these 4 respondent groups for these for 3 questions in the survey. And this I have made a mark here in the middle, that was this one. And this is, as you see, a general question about what the respondent thinks or how they view upon this kind of conversation. I can say it have a very strong support, both within victims and the general public. And I will come back to this. Then maybe this will be sometimes a little bit too much of figures and data, but I will point out the most important thing, what I was thinking. Here we have a question: what significance do you think the following reasons have for the compensation to provide compensation for the violation and humiliation of the crime? And first is the original study, and then is the replica. It's more or less the same if you compare the general public and crime victims, that it's quick and easy to get the compensation. It's more or less 50-50. But that the compensation is high, it's more victims than general public. Maybe this is due to the fact that this is paid by the tax from the taxes. I don't know, but maybe. Then we will, if we come to the third, that the compensation entails a clear reaction to the crime as an acknowledgement to what the crime victim has been through. Here we see more or less the same, but victims are a little bit higher. And then in the last, that is the perpetrator who has to pay and not the state. Here we have in the replica lower result. So there have been something. Yes, and if we look at what people get, they'll get even less today in the replica than before. So it has going down actually, even if the political ambition is to, but that is nothing I see. Maybe it's a miss in the urval in the sample is it can be, and it takes even more time. The female respondents indicate higher compensation. That can be according to sexual crimes because rape gets high. Also, otherwise, when we look here, it's a problematic view I get when I look at this. And there is a development potential, as I write here in this way. When asked whether the criminal injuries compensation has meant satisfaction for the crime victim, just 70% answered that it has done so, only to a limited extent or not at all. So that is the overall impression. I have to speed up a little bit here, so I have to go through more. We have vignette questions in this survey that is interesting, and it's actual case from the crime victim authorities case book, referatsamling. What amount do you think the compensation should be in order to act as a compensation for the violation the woman suffered? Here is different sexual offenses. Two of these is from the original, and then two the other is from the replica. And here is the result in an overview from the original study, and then we can see in mean there is 15, 100, 60, 50, 120, and 75 for the general public. And then it's victims of crime in the lower. They are a little bit lower even in the amount. And I can also show it like this, vignette questions. And there we have sex, females and men. And first is general public, and then it's, okay, and then it's victims of crimes. The females is a little bit lower than the men. I have to speed up now. I'm sorry. So I will go to the final findings that I think is most interesting, even if this is, of course, interesting. It's just significance difference for sexual harassment, and then here is the spread. You can see different amounts. Here is the most, I think. We found a strong positive correlation between the level of compensation received and the importance of the compensation entailing a reaction for the crime for victims of crime who have received compensation for a sexual crime. This indicates that among sexual crime victims there is a need for clear mark against that type of crime by recognizing and compensating the violation that the victim has been subjected to. No similar relationships have been identified for other crimes types. That the compensation entails a clear reaction to the crime as an acknowledgement for what the crime victim has been through is factors most important for sexual crime victims. That was an in-depth analysis we do here with advanced statistical method. So, and here was some summary closing words. Or I'm out of time. This is the last slide. So that the compensation entails a clear reaction to the crime is important, and this compensation has a very good, strong support actually. And among the females and sexual victims, that is even more important. There is no significant difference among several questions and even these vignette studies. So there is some kind of general sense of justice, I can say, even if it's 10 years and it's 4 different groups. That is interesting. And the crime victims experience recognition to a lesser extent, and they also claim to receive lower compensation in this latest study today. That is maybe problematic. And there is more or less the same response patterns. There are differences regarding the view of sexual crimes. There is a broader spread out. And maybe also increased heterogeneity among these response patterns. Okay, and there is references. Thank you.
Thank you so much.